Presented, jury's back in the jury box. Now we'll have the beginning of the defense argument. Mr. Burt.
Thank you, Your Honor. Ladies and gentlemen of the jury, when it boils down to it, when all the lawyers in this case finally stop talking, I think you're going to see that the real issue in this case is what was going on inside the minds of two young men on August 20th, 1989, when they opened fire with two incredibly loud shotguns in the middle of a residential area about a mile away from the police station, and then ended the lives of their parents. Was this an act, as the prosecutor says, of two cold-blooded killers who were bent on committing the perfect crime and thereby to satisfy their lust for greed or their desire to gain back control that they had lost to their parents, or now, as the prosecutor claims, over some dispute concerning a camera recorder? Or was this instead a response of fear and panic that followed year after year after year of abuse by two bullying parents, an abuse which resulted in that final week that you heard excruciating detail about here, which culminated in Lyle Menendez telling his father that he wasn't going to abuse his younger brother anymore? That's really the issue in this case. And the answer to that question is, or may be, a life or death one for Lyle Menendez. And because of the importance of that question, we spent a considerable amount of time since July, when you were selected as a jury, really exploring all aspects of the case. And it was done because Lyle Menendez's life may be at stake in these proceedings. We do operate in a civilized atmosphere here, but it's important, I think, to realize that what's at stake here may be a life or death decision. And that's why we explored at times what to you must have seemed like mind-numbing detail. It was really just an attempt by both sides to do their best job in a case that has very, very, very important consequences for the people who sit at that side of the table. And it's important now that you as jurors, each and every one of you, understand not only the facts of the case, which you've heard since July of this year, but also the law. And I'm going to be talking primarily to you about the law this afternoon. I will mention some facts. Specifically, I'm going to talk a little bit about the coroner's testimony, and I'm also going to talk about the credibility or lack of credibility of some of the people's witnesses. But primarily, I'm going to be talking about the law this afternoon in the time that I have remaining. And then tomorrow, Ms. Lansing is going to explore with you in detail both the defense witnesses as well as some of the prosecution witnesses, and we'll respond to some of the arguments that Ms. Bozanich made during her closing argument. But the law in this case is important. The details of the law are important here, however boring they may seem, and especially boring at 3 o'clock in the afternoon. The reason the law and the details of the law are important here is because, as you're going to learn shortly or tomorrow probably from the judge, you as jurors have two basic duties to perform here. And the judge is going to tell you that your first duty is to determine what the facts are. You are sitting as judges, and you are the exclusive judge of what the facts are. The judge cannot tell you what the facts are. Ms. Bozanich cannot tell you what the facts are. I can't tell you what the facts are. You decide what the facts are in this case, and no one can tell you otherwise if you decide the facts are a certain way. That's one duty you have to perform here, is to decide what the facts are. And you've heard conflicting testimony. It's going to be your job as judges to decide what those facts are. And you're also going to hear from the judge that the second duty you have to perform here is to apply the law as the judge gives that law to you, even if you disagree with it. And the law that the judge is going to give to you will be contained in the instructions, which he's going to read to you. Hopefully you'll have a copy of those instructions to take into the jury room with you. Some of those instructions were discussed by Ms. Pizanich. I probably will be repeating some of the instructions she talked about. I don't think it hurts to hear it twice because these are difficult concepts, even for lawyers. If you understand them already, fine. If you don't, I hope some of the things I'm going to say about the law will be helpful to you. And I'm going to discuss in detail the law. And then, as I say, Ms. Lansing will discuss with you tomorrow how to apply that law to the facts of this case. And as the judge is going to tell you tomorrow, the reason you have to apply the law to the facts of the case is that the ultimate goal here is to arrive at a just verdict. Both sides have a different version of what a just verdict means in this case. The prosecutor thinks a just verdict is for you to convict Lyle Menendez of first-degree murder with special circumstances. And it's her hope that ultimately that decision will lead to another decision which could send Lyle Menendez to the gas chamber. The defense, on the other hand, of course, has a different version of what justice will be in this case. And it's going to be up to you to decide ultimately where justice lies. But it's not a free-flowing decision. You don't just go back and say, well, I think this, or I think this is the way the law should be. It's justice reached within the court's instructions. And that's what guides us through your deliberations, is the law that the court is going to give to you. So what is it legally that you're going to be asked to decide here? And how do you go about doing it? Ms. Pizanich talked to you a little bit about the various options that you're going to have here. And I want to discuss those options with you as she did, but in a little more detail in hopes that it will clarify for you what decisions you're being asked to make here, because it's not just a decision of is Lyle Menendez guilty or not guilty of murder in the first degree. There are other decisions you're going to have to make. And so I want to make sure that everybody understands the various paths that you can take under the court's instruction. And we prepared for you a little flow chart here, which hopefully will be helpful in explaining what the various options here that we're dealing with. And as Ms. Pizanich told you, we start up here with the charge of 187 PC is 187 of the Penal Code. And that's the Penal Code section which defines the crime of murder. And Lyle Menendez in this case is charged with murder with special circumstances. And special circumstances, as you learn at the very beginning of the case, are the thing which distinguishes first-degree murder from a special kind of murder, which ultimately could lead us down here, which is in a second trial where you'd be asked to decide the question of penalty. And at that stage of the proceedings, your only options would be death on the one hand or life imprisonment without possibility of parole on the other. That is the importance, the significance of the special circumstance allegations in this case. And Ms. Pizanich talked about checking off the multiple murder special circumstances if that was an unimportant decision. It's a very important decision because of where it can lead you in the decision flow here. So I'm asking you to keep in mind that the charges here are not just murder, but murder with special circumstances. And in this case, there are two. The two special circumstances are multiple murder and murder while lying in wait. And I'll get back to what those two terms mean in the law. But for now, we start up here with those charges. Those are the charges that you're faced with when you go back into the jury room. So you have the charges, and the first decision you're going to be asked to make, or one way in which you can decide to go about your deliberations in this case, would be to decide, well, is Lyle Menendez guilty or not guilty of murder? Just the question of murder. And I'm going to talk to you in a minute about what murder means. But the first decision you would make is guilty or not guilty of murder. If you were to decide that he is guilty of murder, then the question would become, what kind of murder is he guilty of? your options would be two. He could be guilty of first-degree murder or second-degree murder. If you decided that he was guilty of second-degree murder, your decision would end here, and you would then go back to the second charge of murder, because each charge here, you have to follow the same course. So if you went through as to one charge, for instance, the charge of murder against Jose Menendez, and you decided, well, he's guilty of murder, but we think it's murder in the second degree, your decision as to that charge, that is murder against Jose Menendez, would end right here. You wouldn't go any further, and there'd be no need to reach the decision down here on the question of penalty. But you'd still have a second murder charge, and you'd go back and decide that in the same way. That is it murder? Is he guilty or not guilty of murder? If he was guilty of murder, is it first or second? If it was second, you'd end there, and that would be the end of the trial. You'd still have to decide conspiracy charges, which I'll discuss later. But as far as the murder charges would be concerned, you would end your decision-making there. There'd be no need for further decision. If, on the other hand, you decided as to the murder charge on Jose Menendez not guilty, that you didn't think murder was committed here in any degree, then you would find not guilty, but you would still have a second decision to make. And the second decision would be, okay, he's not guilty of murder. Is he nevertheless guilty of what the court will tell you is a lesser included offense, that is manslaughter? So you'd have to decide, is he guilty or not guilty of manslaughter? And if you decided not guilty manslaughter, you'll be provided a verdict form for that. And by the same token, if you decided he was guilty of manslaughter, your decision-making would end here. And you would then go back to determine the second count in the same way, and you could end up in the same box with the second count of murder. It's only if you decide that, number one, he is guilty of murder, and number two, it is murder in the first degree, do you get to this decision, which is the special circumstance charged in this case true or not true? Now, if you decided that Lyle Menendez was guilty, and he was guilty of murder in the first degree, you'd have to decide whether the special circumstances were true in this case. If you found that they were not true, the case would end there as to that charge. You'd go back up and use the same decision-making for the second count. And again, if you found it not true, you'd end up here and the case would end. And if, but only if, you found that charge true, in other words, you would have found that he's guilty of murder, that murder is in first degree, and the special circumstance is true, would we have a second trial? And it would be at that stage you'd hear some additional evidence, and your options would be limited at that point to life imprisonment or death. And I think it's important to understand that. It's something that we discussed months ago when you were first brought in as jurors, and you may have been wondering how this all plays out in terms of will we have a second trial or not have a second trial. This is the only way you could have a second trial, is if you made all these decisions as to both counts. Now, as you go through the flow chart making these decisions, is he guilty or not guilty of murder? And if you found him, Lyle Menendez, not guilty of murder, is he guilty or not guilty of manslaughter? There is an overriding principle that we operate under in our system. And you're going to see it expressed in various ways throughout the instructions. And one of the ways you'll see it expressed is with this instruction, which says, two instructions actually on one page here. It says, if you are convinced beyond a reasonable doubt that the crime of murder has been committed by a defendant, but you have a reasonable doubt whether such murder was of the first or the second degree, you must give the defendant the benefit of that doubt and return a verdict fixing the murder as of the second degree. So that applies to this decision. When you're deciding guilty or not guilty of murder, if you decide he is guilty of murder and you say to yourself, "Well, I have a doubt as to whether it's the first or second degree," it's your responsibility under the court's instructions to give the benefit of the doubt to Lyle Menendez and find that it's murder in the second degree, and the case would stop as to that count right here. And by the same token, if you found unanimously he is not guilty of murder, and then you went on to decide the question of guilty or not guilty of manslaughter, the court will tell you, if you're satisfied beyond a reasonable doubt that the killing was unlawful, but you have a reasonable doubt whether the crime is murder or manslaughter, you must give the defendant the benefit of such doubt and find it to be manslaughter rather than murder. So if you get to this point in your deliberations where you've said, we don't think it's been proven beyond a reasonable doubt that he's guilty of murder, can't really tell if it's murder or manslaughter, it's your obligation under the court's instructions to give him the benefit of the doubt and find that it's murder and find that it's manslaughter as opposed to murder. Now, reasonable doubt is a principle that's also going to be defined for you by the instructions. And it's probably, from our standpoint, from the defense's standpoint, the most important instruction that you're going to be receiving from the court, because it defines for you what the standard is for your decision. It's not a question, as you might have suspected from Ms. Bozanich's closing argument, of, well, which side do you favor the most? Who's telling the truth here? Choose between the two. No, you'll see from this instruction it's actually three concepts contained in this instruction. A defendant, and the three ideas in here are the presumption of innocence, proof beyond a reasonable doubt, and the definition of what reasonable doubt is. A defendant in a criminal action is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving his guilt beyond a reasonable doubt. And then the second part of this instruction tells you what reasonable doubt is. And it tells you that reasonable doubt is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charges or the truth of the charge. And there are a couple things about that definition I'd like to point out to you. One is, you'll see here that it's after the entire comparison and consideration of all the evidence. And when Ms. Bozanich stands in front of you and says, you really only need to look at this bloody photograph to decide the case, that's contrary to the instructions, because this instruction indicates to you that you're to decide this case not based on one bloody photograph or not based on the testimony of one witness, but the consideration of all of the evidence. And it's only after considering all the evidence that you can decide whether the charges have been proven beyond a reasonable doubt and to a moral certainty, which is defined in this instruction. And I think the essence of this instruction is you have to feel, each and every one of you, because the court's going to tell you that each side in the case is entitled to the individual opinion of each of you. And what that means is no one can be convicted in this courtroom unless all 12 of you agree that the case has been proven beyond a reasonable doubt. And under our system, it's not the majority rules. We're entitled to your individual judgment. And if you feel, based on a consideration of all the evidence, that a charge has not been proven beyond a reasonable doubt, it's your responsibility under the instructions to hold to that view, if that's your view after considering all the evidence, and not cave in to someone else because the majority of people may disagree with you. The court's going to tell you that each side has and is entitled to the individual opinion of each of you. And each of you have to be able to say that you have, when you come out of this jury room and reach a verdict, that each of you have an abiding conviction to a moral certainty of the truth of the charge. To me, the word abiding means lasting, long-term lasting belief or conviction. It's not a suspicion. It's an abiding conviction is something which months from now, you're going to be able to wake up in the middle of the night and think of this case and say to yourself, I did the right thing there because I had an abiding conviction in my decision. I believe beyond a reasonable doubt in the truth of those charges. It's something that I know is going to stick with me. And if you don't get to that state of mind, then under the court's instructions, you aren't entitled to find Lyle Menendez guilty of any charge. A way of thinking about reasonable doubt is in terms of various states of mind you might reach after listening to the evidence in the case. And you'll see along the left side of this chart, I have listed various conclusions that you might come to after listening to the evidence in this case. You might be saying to yourself, well, it might be that Lyle Menendez had the state of mind which is necessary for first-degree murder. And as I said in the first sentence of my argument, the question here is, did he have the state of mind that's required here? Not whether he killed his parents, because there's no dispute about that. The question here is his state of mind, as I'll explain to you later. You might listen to all the evidence in the case, hear the arguments of the lawyers, and say, I think Lyle Menendez might be maybe guilty. And as you move up the sign, this side of the chart, you'll see your suspicions growing. From he might be guilty, he possibly could be guilty. I have a suspicion he's guilty. It's likely he's guilty. Probably he's guilty, all the way up to here. A strong suspicion that he had the state of mind that's required for murder or manslaughter or whatever. All of those states of mind under the court's instructions lead you to not guilty verdicts. And it's only if you get beyond this stage, beyond a reasonable doubt, abiding conviction, moral certainty, that you can say anyone is guilty of any criminal charge, whether it leads to the death penalty or not. That's the way our system works. How important are those concepts in our system? You probably don't recall this, but back in July, you were required to fill out this lengthy jury questionnaire. It was hundreds of questions, and we apologize for that. But it was necessary so that we got to know you in a very short period of time, and it was the only way under the law that we had of doing that. And in those jury questions, which both sides were provided and they used as a basis of evaluating whether you should serve in this case or not, there were two questions asked everyone on this jury panel. The first question we asked you, or one of the questions we asked you, was whether you agreed or disagreed that regardless of what the law says, a defendant in a criminal case should be required to prove his or her innocence. And everybody who's sitting on this jury said that they strongly disagreed with that statement. They strongly disagreed that the defendant should be required to prove his innocence. And the second question we asked you was whether the criminal justice system makes it too hard for prosecutors to convict people accused of crime. And we asked you to comment on that. And I think that your comments as a group probably speak more eloquently than any lawyer could ever speak on how highly we value the concepts of presumption of innocence and proof beyond a reasonable doubt. These are some of the things you said. The Constitution is for all Americans, innocent until proven guilty. The system is set up to protect the innocent and convict the guilty, who sometimes enter the system together. The process must be hard enough to separate the guilty from the innocent, yet fair enough to be just to all it serves. Another person wrote, I believe that it should be hard to convict people accused of crimes to protect the innocent. Someone else wrote, sometimes in the past it has seemed too hard for police and prosecutors to convict, but that is perhaps why our country is the best in the world. I cannot agree to disregard what the law says. We go by innocent until proven guilty. I feel it is the best system I have heard of. I agree that a person is innocent until proven guilty. Defendant is in a tough position already. And if the defendant has to prove his or her innocence, then there is already a negative tag of guilty on the defendant. I think our system works fairly well, and it's the best system there is. It is our basic right to innocence until proven guilty. Defendant is innocent until proven guilty. It is not easy and should not be easy. And lastly, I think the accuser should prove the accusation. And that's a very good, succinct way of saying the way our system operates. The accuser, in this case, the prosecution, should prove the accusation. And this is how strongly this particular group feels about the principles of law I've been discussing with you. And we really took your word for it when you wrote those words down, and we trusted that you were going to abide by what you wrote there in terms of saying that you're going to hold the prosecutor to that burden of proof beyond a reasonable doubt and to a moral certainty. So there's no question in this case that the burden of proof is on the prosecution to prove beyond a reasonable doubt the truth of the charges in this case. And what is it exactly that they must prove? Ms. Bozanich went over it in a little bit of detail, and I want to give you again an overview of what I think it is that's at issue in this case. We start, as we did up on the flow chart, with the charge of murder. And I'm going to be discussing primarily the charge of murder here because, as you'll see under the court's instructions, the conspiracy charge will depend on whether you find, first of all, that there's an agreement. There has to be proof of an agreement. And I have yet to hear from the prosecutor when that agreement was formed or what the agreement entailed. But there must be an agreement, and it must be an agreement to commit murder. Two elements of conspiracy. And the court will instruct you that in order to find an agreement, a conspiracy to commit murder, you must find that Lyle Menendez had the same intent that he would have to have for the charge of murder. So really the charge of, and the same with conspiracy to commit manslaughter, you're going to learn that under the court's instructions, that the charge of conspiracy and the charge of murder really involve the same issues. And it's the case in this particular instance that by resolving the charges of murder, you will also see the way to go on the charges of conspiracy. So it's really the murder charges that I'm going to focus on here, and I'll explain to you a little bit more on the conspiracy charges later. But the basic charge of murder in this case is, and the definition of murder was given to you by Ms. Bozanich. There are three elements which she must prove. And under the court's instructions, as we go through these crimes, there are certain elements or parts to each crime I'm going to be discussing. The prosecution is required to prove all the elements. She can't get by with proving 2 out of 3. She can't say, well, I showed you that a human being was killed, and I showed you that the killing was unlawful, and there's a little bit of doubt on the malice aforethought part of it, but 2 out of 3 is not bad, so I win. No, it doesn't work that way. She only wins if she can prove beyond a reasonable doubt and to a moral certainty that each element of whatever charge is being discussed, be it murder or manslaughter, is proved beyond a reasonable doubt. So the 3 elements of murder are at the top of this chart. And there's actually a 4th, which is the defendant was the person who committed the murder. That is not a contested issue in this case. As I indicated to you, it is a contested issue as to whether it's murder, but it is not a contested issue that Lyle Menendez was the person who killed his parents. That's a homicide. The question is whether it's a murder or something else. So the three elements that are here that I'm going to focus on are a human being was killed, of course, that's not being contested. The killing was unlawful, and it was done with malice aforethought. And the third element is the element that is really at the heart of the contest between the prosecution and defense in this case. And the court is going to define for you what malice is. And the court will tell you that malice is express. And this is a funny definition because the court will not tell you what it is. The court does not say, here's what malice is. This is the way the instruction reads. It says malice is expressed when there is manifested an intention unlawfully to kill a human being. There's also going to be a second kind of malice that the court's going to tell you about, and that's something called implied malice. It's not listed on this chart, but another way that you can find malice is implied malice. And implied malice usually applies to a situation where someone does not have an express intent, has not manifested an express intent to kill someone, but he does some act that is so highly dangerous that it's the same under the law as having an intent to unlawfully kill somebody. An example that's usually given is someone comes into a crowd of people with a bomb or a hand grenade and says, gee, I don't know anybody in the audience out here, but I think I'm going to throw this lighted hand grenade into the audience. Well, that person may not intend to kill any one particular person, but the act of throwing a hand grenade into a crowded room is so dangerous that the law in those circumstances equates that act with an intentional killing. And that would be an example of implied malice. What I'm going to focus on in the instructions, because I think it simplifies it, is the concept of express malice. And express malice is manifested when there's an intent unlawfully to kill a human being. You'll see under the court's instructions that intent to kill is also an element of manslaughter. And the court's going to tell you about the difference between murder and manslaughter. And you'll see that voluntary manslaughter is an unlawful killing where there is an intent to kill, but no malice aforethought. And involuntary manslaughter is an unlawful killing where there's no intent to kill. And murder is an unlawful killing where there is express malice aforethought. And express malice aforethought occurs when you have an intent to kill and there's nothing else which reduces that intent to kill to manslaughter. Once you've found that malice is present, once you've said that there is, in this evidence, proof beyond a reasonable doubt that the defendant intended unlawfully to kill a human being, and it is not second degree, and it is not self-defense or unreasonable self-defense, I should say, and it's not sudden quarrel or heat of passion. If you find that there's express malice, then under the decision tree that we started with here, you would have to decide whether it's murder in the first degree. And murder in the first degree has various elements or parts, just like murder. To get it beyond murder and into the category of murder in the first degree, the prosecution must prove certain things. And as Ms. Bazanich said, the instruction on first degree murder is lengthy, fairly complicated, but it's important that you understand it, because her approach was to say, well, you all have some idea in your mind about what a first degree murder is, but our own ideas of what a first degree murder are or what they should be may differ with what the law says a first degree murder is. And you might say to yourself, well, what difference does it make? The victim of a manslaughter is just as dead as the victim of a first degree murder. And so why should the jury be concerned with these fine legal distinctions between first-degree murder, second-degree murder, manslaughter. I think the answer to that is that the law recognizes that, as the prosecutor said in her closing argument, people are just human. They have certain human frailties, and an intent to kill someone that's formed under extenuating circumstances, although it may be unlawful and therefore an act of manslaughter, is not in the same category as a willful, deliberate, premeditated murder. And by the same token, a willful, premeditated, deliberate murder is not in the same category as a second-degree murder, which is a murder where you have an intent to kill, but no evidence that it's deliberate, premeditated, and so forth. So the law makes these distinctions in recognition of the fact that people are not equally culpable and that all unlawful killings are not the same. Some unlawful killings are more culpable, more blameworthy than others. And that's why these distinctions are important. That's why it's important that you understand what the distinctions are in this case, even though it gets somewhat technical. First-degree murder is, and there's a typo up here, but all three of these elements must be proven to get first-degree murder. Prosecution must prove, in order to get a conviction for first-degree murder, that the murder was willful, deliberate, and premeditated with express malice aforethought. That's what first-degree murder is. And the word willful, as used in the instructions, means intentional. The word deliberate means formed at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. And then the instruction goes on to tell you the circumstances under which first-degree murder would be present. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was a result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not upon a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. And then it goes on to say, the true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing at murder in the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he decides to and does kill. So, under the instructions, in order for it to be first-degree murder, you must find that it's deliberate, that is careful thought and weighing for and against the decision to kill. You must find that it's premeditated, that is, that the thought is considered beforehand. And you must find that it was committed with express malice aforethought, that is, that it was committed with an intent unlawfully to kill a human being. And in order for the murder to be of the first degree, you must find that the killing was by a clear, deliberate intent to kill formed upon a pre-existing reflection. No sudden heat of passion or other condition. If there is a sudden heat of passion or other conditions, such as we'll discuss down here, unreasonable self-defense, which precludes the idea that someone was carefully weighing the considerations for and against death, then it's not murder in the first degree. It would be, in those circumstances, murder in the second degree, unless it was something less than murder in the second degree under the the instructions, which I'm going to talk about now. So in this case, if you were to say, after considering all of the evidence, if you were to choose that path in the chart that I began with, which says, I think that this case was murder, I think that murder was committed here because there was express malice, an intent unlawfully to kill a human being. But I don't think there was the careful thought and weighing for and against the killing, and I don't think it was premeditated. Then the most it would be is murder in the second degree, because that would be a murder where you have express malice aforethought, but the evidence in your mind is insufficient to establish premeditation and deliberation. If you got to that point, then you would have to decide the question of, if you got to the point where you thought it was neither, that is, you didn't think it was murder in the first degree because there was no deliberation and premeditation, and you said to yourself, I have to then consider the question of whether it is murder or manslaughter, then you would get to the next instruction, which tells you about the distinction between murder and manslaughter. And again, I realize this is incredibly tedious, but it's the only way we have of explaining to you in a crash course what the law is so that you can intelligently decide this case. So the distinction between murder and manslaughter, as I mentioned a moment ago, murder requires malice, manslaughter does not. When the act causing the death, though unlawful, is done in the heat of passion, or is excited by a sudden quarrel such as amounts to adequate provocation, or in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, the offense is manslaughter. In such a case, even if an intent to kill exists, the law is that malice, which is an essential element of murder, is absent. And it goes on to say, to establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder, and that the act which caused the death was not done in the heat of passion or upon a sudden quarrel, or in the honest, even though unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. So you'll see under that instruction that when you're deciding what distinguishes or what reduces murder to manslaughter, you basically have two options. First of all, you have the option of self-defense. And under the law, if someone actually and reasonably believes that it's necessary to defend themselves because they honestly and reasonably believe that they're about to be killed or they're about to suffer great bodily injury, that person is not guilty of any crime. That would lead to an acquittal. In this case, you're going to be given instructions about a different kind of self-defense, and it's a self-defense which is called imperfect self-defense. Imperfect self-defense is where you have an actual, the person really actually believes, but he unreasonably believes that it's necessary to defend himself. And in that situation, the crime is manslaughter. It's voluntary manslaughter if there is an intent to kill. It would be involuntary manslaughter if you were acting unreasonably and you didn't have an intent to kill. An example of that would be, at various points in the testimony, Lyle Menendez was asked, what were you thinking when you put the gun against your mother's cheek? And he responded, on several occasions, I wasn't thinking. I was acting in a panic state. I was acting automatically. And Dr. Burgess attempted to explain to you what happens when the emotion of fear takes over in someone who has been abused, and that you, in those circumstances, the research is showing, go into an automatic state where you are not thinking. It is not a conscious thinking process on your part. You are merely responding, and your body is acting automatically. And you recall her testimony in that regard. And she was asked, this is a question from the transcript, let's talk about it in terms of fight or flight. Let's say somebody is coming at me to attack me. Their arm is raised, looks really angry. Now I've got to decide, my body's got to decide whether to fight him or to run. Now, what is going on biologically in this second stage when I'm being faced by this attack? She says, well, that's essentially when all of the hormones are spreading to tell the body to pick up two of these decisions of what you're going to do, make a decision. It generally is automatic because people begin to use, they are not even going to think because it's instinctual. The fear response is present in the body to protect the person from danger. So survival becomes the main goal, if you will, or why this whole system gets activated. So it is a physiological response to fear, and it is an instinctual response. You're not consciously thinking during this process, and she indicated that someone who had been abused was more likely to have that sort of an instinctive physiological response. And that is one way in which the evidence concerning the abuse history is relevant to your decision here. It's not relevant to make someone look like a bad guy and therefore to try and encourage you to reach a decision that because Jose Menendez was a bad guy, we're encouraging you to adopt some theory of vigilantism here. The evidence was offered properly because one of the decisions you're going to have to make is, was Lyle Menendez acting intentionally or was he acting instinctively during this time period, during the final week, when his fear response and the reaction to what was going on with his parents was combined with his history of abuse. And one of the ways in which you would find that the killing here, although unlawful, was involuntary manslaughter would be if you decided that as a result of considering all the evidence, you believe that Lyle Menendez actually, but unreasonably believed that it was necessary to defend himself, and you further believe that he wasn't thinking, was not consciously intending to kill anyone. And in those circumstances, the verdict would be involuntary manslaughter because there is no intent to kill, although that killing is still unlawful. You will see when you look at the instruction on unreasonable self-defense, imperfect self-defense, a couple of things. A person who kills another person in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury kills unlawfully, but does not harbor malice aforethought and is not guilty of murder. This would be so even though a reasonable person in the same situation, seeing and knowing the same facts, would not have had the same belief. Such an honest but unreasonable belief is not a defense to the crime of voluntary manslaughter. It's also not a defense to the crime of involuntary manslaughter. And you'll see by this instruction that the belief can be unreasonable and that the crime is nevertheless manslaughter and not murder, even though a reasonable person in the same situation, seeing and knowing the same facts, would not have had the same belief. So when Ms. Bizanich says to you, well, if we had known Jose Menendez was a child molester, we certainly would have prosecuted him. That really is missing the boat by a wide mark here, because the question is, first of all, Lyle Menendez had no idea who Ms. Bizanich was or what the practices of her office were or what the options were in terms of prosecution. The question is, what did the person even though you as reasonable people in the same situation, seeing and knowing the same facts, would not have had the same belief, you have to put put yourselves in the shoes of Lyle Menendez and say, well, we have to view this from his perspective, his situation, in order to decide whether he actually had a belief in the necessity to defend himself against the threat of life or great bodily injury posed by his parents. And so to do that, you have to say to yourself, not what you as reasonable people would consider to be the right thing in those circumstances, but if you were in that situation with the history of abuse that Lyle Menendez had, was there something about his situation and his life history which actually caused him to have that belief? And if there was, then he's only guilty of manslaughter. Voluntary manslaughter if you found an intent to kill, and involuntary manslaughter if you found there was something less than an intent to kill. And again, the prosecutor harped on the fact that we attempted to show that Jose Menendez was an abuser here. And we did produce evidence in that regard as to both parents. The court will instruct you that that was properly received in this case. And the court's going to give you an instruction which reads, evidence has been received in this case which may tend to show the character of the alleged victims for violent or otherwise abusive behavior. It may be reasoned that a person of such character for violent or abusive behavior would be more likely to act violently or abusively on any given occasion. However, evidence of such character for violent or abusive behavior may be refuted or rebutted by contrary evidence. Any conflict in the evidence of the alleged victim's character for violent or abusive behavior and the weight to be given to such evidence is for the jury to decide. And then the court's also going to instruct you. One who has received threats against his life or person made by another is justified in acting more quickly and taking harsher measures for his own protection in the event of an assault, either actual or threatened, than would be the person who would not receive such threats. If, in this case, you believe that one or both of the deceased made prior threats against the defendant, and that the defendant, because of such threats, feared greater peril in the event of an altercation with one or both of them, you are to consider such facts in determining whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. Now, what does that mean? That means that we're not just throwing dirt at Jose and Kitty Menendez in this case. The evidence was produced for you because under the court's instructions, you are obligated to look at Lyle Menendez's situation from his perspective and to say to yourself, well, if I was in his situation, if I had lived with these people, if I had suffered the kinds of abuse that he testified to that was corroborated by other witnesses, would I have some actual fear that my parents were about to harm me when I told them that I was going to disclose that he was a child abuser? And the parents, after that threat by Lyle was made of disclosure, then went through a series of acts, and those acts led to an actual belief by Lyle Menendez that his life was in danger. You have to be able, under the court's instruction, to put yourself in his shoes and to say to yourself, I can't look at this from the perspective of the reasonable person who didn't have that history. I have to be able to say, under these instructions, that he did not honestly believe that he was in danger. And the fact that the parents abused him and his brother in the past, the fact that they witnessed abuse in the past, the fact that they heard threats to kill other people is relevant in this case because it shows that Lyle Menendez had an actual, although you may decide, unreasonable belief that he was about to be killed by his parents. And the standard here is not whether a reasonable person would have done something else, like fled the house. All that questioning on cross-examination about why didn't you run away is really designed to address the question of whether it's an actual and reasonable belief, but it does not in any way address the question of whether he actually believed his life was in danger. And so you take into account the history of abuse in deciding whether he actually believed that certain things his parents did caused him to fear for his life. And that's why that evidence was produced. And you'll see under the instructions that I just read to you that the grounds for fear do not require actual danger, but only the honest belief of peril, and that the burden is on the prosecutor to prove beyond a reasonable doubt that self-defense was not justified, and that if a reasonable doubt exists, the defendant is entitled to the benefit of that doubt. And under those circumstances, you would be obligated to find that the most serious crime that was committed here was voluntary or involuntary manslaughter. A second way in which murder is reduced to manslaughter is sudden quarrel or heat of passion. And there will be a series of instructions about sudden quarrel and heat of passion. And you'll see under the instructions that there is identified the kind of passion that we're talking about that will reduce murder from manslaughter. Neither fear, revenge, nor the emotion induced by an accompanying or following an intent to commit a felony, nor any or all of these emotional states in and of themselves constitute the heat of passion referred to in the law of manslaughter. Any or all of such emotions may be involved in a heat of passion that causes judgment to give way to impulse and rashness. Also, any one or more of them may exist in the mind of a person who acts deliberately and from choice, rather whether such choice is reasonable or unreasonable. The interesting thing about this instruction is it talks about, first of all, the emotion of fear as being the basis for a heat of passion defense. And in this case, it is the defense's contention that the evidence in this case shows that the defendants, Lyle and Eric Menendez, were acting out of fear. And in that sense, the heat of passion doctrine is very similar to the self-defense principles that we just talked about. When you were relying on fear as a emotion under heat of passion, fear is very similar to the fear of death or great bodily injury. You'll see under the court's instructions that fear can serve as a basis for heat of passion, but so can other emotions. And interestingly, revenge is mentioned. And even more amazingly, the emotion induced by an accompanying or following an intent to commit a felony. So apparently someone can go into a liquor store and be excited about committing a robbery, and in the emotion of committing that felony, someone is shot. That killing could be, under this instruction, a heat of passion under certain circumstances, because the excitement of the moment is something that is taking over and controlling that person's emotions. And even though the person is acting unlawfully, his intent to kill is formed as a result of the heat of passion accompanying or following an intent to commit a felony. And under the law, that person could be guilty of manslaughter. Here, of course, you have a much less.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
How should I say it? Sinister emotion, and the much less sinister emotion is the emotion of fear. But it's interesting, I think, because the prosecutor is claiming that the brothers acted out of I'm not sure what she's claiming because there's been so many theories advanced as to motive, I can't keep them all straight. She originally began during her opening statement talking about money, financial gain, and there was also some talk about committing the perfect murder. And in the closing argument, we're now talking about camcorders and the desire to be free of the parents' control. So the issue of what motive is involved in these killings is not altogether clear. But under the people's main theory, the theory that they tried to advance throughout the case, the brothers were killing out of the desire to be freed of their parents' control. And there were questions asked on cross-examination along the lines of, isn't it true that you killed your parents because you were fed up with the abuse that was being inflicted upon you? Even under the prosecution's version of facts, if you were to decide, yeah, I think that's what the motive here was, that these brothers were killing out of being fed up with being abused and the control that their parents were exercising over them. Even under that interpretation, which we say is totally wrong, you could have voluntary or involuntary manslaughter because it would involve the emotion of revenge, either fear, revenge, or emotion induced by a company. And it goes on to say, any or all of such emotions may be involved in heat of passion. So even under the prosecution's version of the case, you can have voluntary or an involuntary manslaughter. There are several other principles about heat of passion that are important for you to understand. One of them is the court's going to instruct you that the passion necessary to constitute heat of passion need not mean rage or anger, but may be any emotion, including fear, which causes a person to act rashly and without deliberation and reflection. No specific type of provocation is required to generate the passion necessary to constitute heat of passion, and verbal provocation may be sufficient. If someone verbally provokes you, and as a result of that verbal provocation, you decide to kill that person, and you do it under circumstances where you don't have time to cool down, then that can be manslaughter, even though you kill that person unlawfully and you do it with an intent to kill. The court's going to give you some instructions on cooling period. And cooling period typically arises in a situation where the emotion being relied on is anger. If someone is angry at somebody else, that anger over time subsides. And the law says that if there's sufficient cooling period between whatever it is that provokes you and the time that you kill that person, then it would not be a proper charge to convict someone of manslaughter because you've had time to regroup and to get back your presence of mind. And as I say, typically that instruction applies in a situation where you have anger as the emotion. Somebody verbally provokes you, calls you son of a bitch, you get very angry, but you go out for a walk. You can't 20 minutes later, after your anger has cooled down, come back and shoot the person. That wouldn't be right, and that's murder, not manslaughter. But in this case, fear is a different kind of emotion, because fear, based on everything we know about it and experiencing it ourselves, is not the kind of emotion which typically cools down. In fact, it can grow over time. And so you have to keep that idea in mind when you consider this idea of cooling period, because cooling period does not work real well with some emotions, and fear is one of them. And the court's going to tell you that a defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time. Now, what does that mean? Just like in the case of unreasonable self-defense, you can take into account the history between two people in deciding whether the person is acting in the heat of passion. If someone is your arch enemy and over a long period of time has consistently threatened or abused you, then it's more reasonable for you to act when that person threatens you again than it would be for someone who was just a stranger to you and you had no history with. That again is why the abusive conduct by the parents going way into the early years is relevant here. When Lyle Menendez talks to his father at age 13 about stopping the abuse of his brother, and the father says, it'll stop, and this is just going to be our secret, and don't tell anybody or I'm going to kill you. That's something which plays later on into whether Lyle Menendez was acting in the heat of passion when his father made the same kind of comments about whether he was going to allow Lyle to go out and reveal the abuse secrets to the world. So again, you take into account the entire history, and those will be gone into in some detail by Miss Lansing tomorrow. But it's important to realize again that abuse history and the evidence which you heard about the early relationship between the parents and the Menendez brothers is something which is properly before you so that you can decide whether these killings were committed in the heat of passion. So just to complete this chart, passion can be fear or any emotion that causes judgment to give way to impulse and rashness. No specific type of provocation is required. Verbal provocation may be sufficient, and it may be the result of a series of events which occur over a considerable amount of time. And again, the burden is on the prosecutor to prove beyond a reasonable doubt that the defendant did not act in the heat of passion. As you go through all of these decisions, you'll see that what you're primarily dealing with here is mental states of mind. That is, for murder, did the defendant kill unlawfully and did he kill with express malice aforethought? For first-degree murder, did he kill deliberately and with premeditation? Second-degree murder, did he kill, if there was no premeditation and deliberation, did he kill with express malice aforethought? For manslaughter, did he kill with the actual but unreasonable belief in the necessity to defend himself? And for sudden quarrel, heat of passion, did he kill out of a heat of passion? Was his intent to kill formed as a result of a heat of passion? All of those decisions require you to look at the mental state of Lyle Menendez. And the court's going to tell you that a crime is only committed when there's a joint operation of act, in this case, killing someone, and a certain mental state in the mind of the person. So it's Lyle Menendez's mental state at the time of the killings, which you have to look into and decide, was he acting with malice? Was he acting with deliberation, premeditation? Was he acting in a reasonable self-defense? Was he acting out of heat of passion? All those decisions have to do with mental state. And mental state is something, because it goes inside someone's mind, that cannot be proved directly. Someone can talk about their mental state, but mental state is something that must be proven by circumstantial evidence. And the court's going to tell you that there are basically two kinds of evidence. Direct evidence, that's where someone sees something. Lyle Menendez testifies, I killed my parents. That is direct evidence. He was an eyewitness to the killings. Directly proves that he in fact did kill his parents. But his mental state at the time, he directly testifies to it because he testified that he acted out of fear, out of panic. That's a direct proof of what his mental state is. But generally, you are relying on circumstantial evidence to prove mental state. And there are special rules which apply to circumstantial evidence, which I'd like to talk to you about just briefly. As I said, the court's going to instruct you that circumstantial evidence and direct evidence are the same, entitled to the same weight. But he's also going to give you a special instruction on circumstantial evidence. And the circumstantial evidence instruction says, however, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count is susceptible to two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Jurors often get confused about that last sentence, and prosecutors often jump on this last sentence and say, oh, that means that if Lyle Menendez's interpretation of the evidence is unreasonable, you have to reject it and find him guilty. No, because the evidence is still subject to proof beyond a reasonable doubt. It's the prosecutor's burden under the other instructions that I read to you to prove beyond a reasonable doubt that Lyle Menendez is guilty. And so this is an instruction which is given in connection with a beyond a reasonable doubt instruction. And it tells you that if you reach that point in your deliberations where you think, well, it could be one of two things. Either he did have malice or he didn't. It's equally plausible as to each. There's evidence to support each. His version is not unreasonable. Prosecution's version is reasonable as well. Under the instructions, it's your duty to find that the charge has not been proven. It would be your duty to find Lyle Menendez not guilty under those circumstances. And there's another instruction which applies circumstantial evidence, the rule that I just read to you, to mental state. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crimes charged or any lesser crimes unless the proved circumstances are not only consistent with the theory that the defendant had the required specific intent or mental state, but cannot be reconciled with any other rational conclusion. Also, if the evidence as to two such specific intent or mental state is susceptible of two reasonable interpretations, one of which points to the existence of the mental state and the other to the absence, you must adopt that interpretation which points to the absence of the specific intent or mental state. And then if, on the other hand, one interpretation appears reasonable, the other unreasonable, you must accept the reasonable, reject the unreasonable. This then is how you weigh circumstantial evidence which proves specific intent or mental state. And you'll see from this that the instruction directs you to look at the circumstances surrounding the commission of the act to decide what mental state was taking place at the time the act was committed. And that was one of the reasons why we presented the testimony of Ann Burgess, because her testimony was directed to the circumstances surrounding the act, and specifically the crime scene evidence and what can be inferred from the crime scene evidence as to whether the person who committed whatever happened there that day was acting with deliberation or premeditation, was acting carefully after weighing the decisions for and against, or instead was acting out of fear, and do the circumstances of the crime scene point in one direction or the other. And you recall Dr. Burgess was a person who has been working with the FBI for 10 years as an expert on victims. And it's been her expertise, and her life has been devoted to helping law enforcement develop ways to better understand how to catch people who commit crimes by looking at the crime scene. When the prosecutor refers to her as a hired gun, I find that incredible in light of this person's background and training. This is a person who is affiliated with law enforcement. She's worked with the FBI, still works with the FBI, and she was the one who was responsible for the crime classification that the FBI uses to catch criminals. And yet she is painted as a hired gun along with every other expert in the case who you're supposed to just completely reject and not put any weight on whatsoever. And I think a fair judgment as to Dr. Burgess is that she's an incredibly qualified person. She's someone who offered testimony, I think in this case, which was helpful in analyzing the crime scene, as well as analyzing what the effects of fear are. And she's someone who is not subject, I don't think, to a fair charge that she's simply a person who would come into a court of law, take an oath to tell the truth, and lie because she was getting paid money. And that sort of broad-brushed attack on our defense witnesses, I think, needs to be carefully looked at by the jury, because I think it's an unfair attack, and I think it really attempts to minimize the importance of the expert testimony which was presented to you, and which, as you'll learn under the court's instructions, was properly presented to you. Sometimes experts can contribute something that we as common folk don't know about. And I don't know about you, but I have not spent a lot of time analyzing crime scenes or talking to serial killers or researching victimology as Dr. Burgess has. And I think she did have something to contribute to this case. She was asked her opinion of whether the crime scene in this case was an organized or a disorganized crime scene under the criteria used by the Federal Bureau of Investigation. And she said, the question was, and in applying these guidelines and analytical methods to the crime scene here, did you reach a conclusion about what kind of crime scene this was? Answer, yes, I did. And what was that? Answer, and I'll preface it, if there may be indicators of both organized and disorganized, but generally in this crime scene, I saw more evidence of disorganized organization. Question, and did that indicate to you a lack of planning to avoid detection? Answer, yes. Question, and does it appear to be a disorganized crime scene because you cannot see any significant evidence of planning to avoid detection? Answer, yes. Question, now, what under the FBI's criteria, what was disorganized about the crime scene? Answer, location, choice of weapon, injuries to the victim, emotionality, indicators of emotionality, and lack of staging. And she went on to explain how the use of the particular weapon, in this case a shotgun in a busy residential area, was an indicator to her as an expert and as an analyzer of crime scenes that this was not a real carefully thought out, well-planned, deliberate, premeditated scheme going on here, given the fact that this was numerous shotgun blasts shot off in the middle of a Beverly Hills neighborhood. And she also talked about injuries to both parents. And this goes to the coroner's testimony as well, describing the pattern of injuries that he described on both Mr. and Mrs. Menendez. Question, now you said the third factor leading to a characterization of disorganized was the injuries to the victims. And what do you mean by that? Injuries to victims is that you look at where on the body in a gun shooting case, where the injuries are, not only where they are on the body, but the number. And why does that tell you something about organization versus disorganization? Answer, more organized type of of person who shoots is going to use the minimum amount of shots to accomplish the task. She then went on to describe emotionality and why that was an important consideration. And she said that the term emotionality is sometimes used overkill, that there is a large, more shots are fired than is necessary to accomplish the task. And that was a situation in this crime scene, that a large number, far more shots were fired than were necessary. And she was asked, in this particular case, what analysis did you come up with concerning where the injuries were on these two decedents? She said, my analysis is that the injuries were random, if you will. They were to all parts of the body. There was not one area singled out. Question, what conclusion based on this analysis could you draw? Answer, well, that would speak to a more pervasive emotion than just one emotion, such as anger or rage or what, but would speak to a wider aspect. Questions such as, she says, such as fear. And then she went on to describe how the presence of the absence of shells and the presence of the absence of a weapon at the scene was an indication of an organized crime scene. But she pointed out that there was a difference in organization, post-crime planning, planning during the crime, and pre-crime planning. And you'll see under the court's instructions on first-degree murder that what the law is concerned about is pre-crime planning, because deliberate, premeditated murder is committed when someone before the murder carefully weighs and considers the question of killing, and after carefully weighing and considering the reasons for and against the killing, they go ahead and make the decision and kill. If after that decision is made and the person kills somebody and then does something else, then they're into the post-planning period, and it can be subject to two reasonable interpretations. For instance, if someone kills in the heat of passion, you kill someone because they've abused you and they've just made a remark to you which is threatening, and you go ahead and kill that person. You shoot them someplace where no one else is around, and you realize, I just killed unlawfully. I know I just committed manslaughter. I don't really want to go to jail. I'm going to do something to hide this crime. You hide the gun, or you bury the body, or you leave the jurisdiction, or you take money from the person and you spend it. You have to be careful, because what you do after the crime may very well reflect on what your state of mind is days or minutes or months after the crime, but it doesn't necessarily tell you a whole lot about what you were thinking at the point in time when the trigger was pulled. And that's the point in time when the law focuses you on, because that's the point in time when, if a crime is committed, there has to be this union of act and mental state. So it's pre-crime planning that the law looks to. And Dr. Burgess attempted to analyze a crime scene in such a way that you would be able to look at it and say, what is there about this crime scene that points to deliberation, premeditation, or malice? Does it point to that, or does it point to something more in the nature of fear and heat of passion? Now, you may give the prosecution the benefit of the doubt and say, I think the crime scene points to premeditation and deliberation. That's one reasonable interpretation of the crime scene. You may also say it's equally reasonable that because of the way the crime scene looked and the circumstances of that crime scene, it's just as reasonable to infer fear and heat of passion from that crime scene. And under the court's instructions that I just reviewed with you, it would be your obligation to accept the interpretation which pointed toward innocence or to the lesser included offense and find Lyle Menendez not guilty. And that's an illustration of how circumstantial evidence is used in this case. I want to talk briefly, and I want to try and finish today, so I don't want to go too much longer. briefly about the testimony of Dr. Oziel. How else do you prove that someone's mental state was what it was at a given period of time? You can do it through statements of the defendant. And the court's going to give you an instruction on what the law calls admissions or confessions. If someone says to someone else, I killed this guy and I did it with express malice aforethought, he's not going to use those words, but he may say, I did it with the intent because I wanted to kill that son of a bitch. And that witness comes in and testifies to that. That's a pretty good indicator of what that person's mental state is. If two things can happen. Number one, in that situation where some person's coming in and saying, this other person made a statement to me, the question for you as jurors to decide is, number one, was the statement made? Did the person hear it correctly? Is that person honestly reporting to us what was said by the other person? And then the second question is, if the statement is being accurately related to you, is the person who's doing the speaking truly as to what their intentions are? Because if the person is not speaking truly as to what their intentions are, then the statement is not a very good indicator as to what the person's mental state was at the time of the crime. And that type of analysis applies to the testimony of Dr. Oziel in this case. The prosecutor attempted to deal in her closing argument with Dr. Oziel by saying, well, the defense is going to say he was our star witness, but really the only reason we called him was so that he was a witness that we had to call in order to prove that it was the defendant who was the killer, to prove the question of identity, not the question of motivation. And the only importance of Dr. Oziel was that he testified that Lyle Menendez admitted to the killing, and he had to be called because we had to prove as prosecutors beyond a reasonable doubt that he was the killer, even though the defense says that they conceded that that was the case. That's a very interesting way of dealing with Dr. Oziel, because when the case began, the prosecution went into his statements at length during her opening statement. And she went into him at length because she was relying on him at that point, before any evidence was offered, to try and show to you, to prove to you what Lyle Menendez's motivation was. And you recall from the opening statement that at the beginning of the case, she was claiming that the evidence would show that Lyle Menendez's motivation was that he and his brother were committing the perfect crime, and that was proved up by the testimony of Dr. Oziel. And she also indicated that the evidence would show that they did it out of hatred, out of greed, and various other motivations that she attributed to the killings, but they all centered on Dr. Oziel and what Dr. Oziel was supposedly going to testify to. As it happened, Dr. Oziel sort of disintegrated as the case progressed. So by the end of the case, there's really not a whole bunch left of his credibility, and I don't intend to spend a lot of time on it. You heard the evidence, and you heard all the evidence in regard to his credibility. I agree with Ms. Bazanich, this is not divorce court, but Dr. Oziel was offered to you, at least according to the opening statement, as a witness who was going to prove the motivation for these killings. And it became important to show whether he was telling the truth or not as to what he heard. And of course, if he heard what he says he heard, then that would put someone in fear. If someone comes in to you and says, yeah, we killed our parents and I'm going to kill you, Dr. Oziel, that would put somebody in fear, and you would expect someone who had received that kind of information to act like they were in fear. So we explored with you what Dr. Oziel's behavior was after he supposedly received that information, to see if, in fact, he was acting like a person who was in fear for his life or had been threatened. And all the testimony about his behavior went to show that Lyle Menendez's testimony about what he told Dr. Oziel is the more believable of the two witnesses here, because he denied ever threatening Dr. Oziel. He denied most of the outrageous statements that Dr. Oziel said were made to him. And Dr. Oziel supposedly said these statements were made to him after he had warned Lyle Menendez. Now remember, Lyle, if you threaten me, what you say to me is not confidential. And according to Dr. Oziel's version of it, it was after telling Lyle that he was not subject to confidentiality that Lyle Menendez went ahead and threatened Dr. Oziel, and not only threatened him, but supposedly, according to Dr. Oziel, signed on to a version of first-degree murder. Because you remember, according to Dr. Oziel's testimony, he offered him two options, which incredibly are almost verbatim the legal definitions which you are required to decide here. Review Dr. Oziel's testimony, and he's got Lyle Menendez faced with the choice of, Lyle, is this heat of passion or is this premeditated or deliberate killing? And according to Dr. Oziel, he signs on to the premeditation deliberation package. This is supposedly after Oziel tells him that what you tell me is not confidential. Well, if he had signed on to that version, would you expect Dr. Oziel to be acting the way he was acting in the days and months following receiving that information? And the tape recordings, which were played for you during the testimony of Ms. Smith, and whatever you think about her credibility, the tape recordings have the voice of Dr. Oziel on them. They were offered to show that Dr. Oziel, first of all, lied to you about several things, and second of all, that he was not someone who was in fear of anybody during this period of time that he said he was in fear. So the first question with respect to Dr. Oziel is he testifying truthfully about what was said? And I think you have to look is who this man is. He is a psychologist, a certified sex therapist, who at the time he was counseling the Menendez brothers was on probation for having a dual relationship with his clients. And he was on probation from 1988 to 1991. He was on probation during the time that these conversations supposedly were overheard by him. And at the time he testified at trial, he was under accusation by the Attorney General's office for, again, dual relationships. So as he's sitting here testifying, you have to wonder what his motivation is for not telling you whether, in fact, he was attempting to somehow manipulate the brothers or manipulate other people for his own benefit. He's certainly not going to admit and therefore jeopardize his license, which is under question because of the present accusations, by saying that Miss Smith was his patient. And yet there's evidence in front of you that he's writing excuses for her for court that, based on one falsification of the excuses that he gave, that he was considered for prosecution by the same DA's office that's prosecuting this case, and the prosecution was rejected for statute of limitations problems, whatever those were. But I think you have to consider, is Dr. Oziel telling you the truth, what this man's motivations are? And is this a person who has his own agenda here to save his license? Did he have an agenda at the time these events he's testified to are taking place? Was he attempting to manipulate his girlfriend and his wife by using some information he had received from the Menendez brothers in order to control and manipulate these women? Is he the type of person that preys on people like Miss Smith or preys on people who were in unfortunate circumstances? Was he attempting or in the process of following his MO of preying on people when he on his own contacted the Menendez brothers in the days following the murder, and when he later tells Miss Smith, get out of here, Judalon, there's $14 million involved in this? What are his motivations? Is he a clean witness in this case? And I think the answer is clearly not. And I think in response to the answer being clearly not, the prosecution has to bail out of Dr. Oziel. He's no longer the star witness, because to make this case depend on Dr. Oziel's credibility is to make it depend on quicksand. So now the star witness becomes Perry Berman. And the reason it's explained to you that Perry Berman is the star witness is because he had a conversation with Jose Menendez, and Jose Menendez said he was going to help Perry Berman out. And since he said he was going to help Perry Berman out, doesn't that indicate that he was not contemplating killing Lyle Menendez? Well, the question here is not whether Jose Menendez was in fact plotting to kill Lyle Menendez. That's beside the point. The question here is, did Lyle Menendez actually believe, as a result of what he saw and what he heard and the history he had undergone with Kitty and Jose Menendez, did he actually believe he was in danger? So how Perry Berman and the woman from the sporting goods store all of a sudden become the star witness and Dr. Oziel is dropped from the spotlight, I think is apparent. It's an attempt to bail out of a very uncomfortable situation where the prosecution's star witness has turned into not so much of a star after all. The two other issues I wanted to discuss with you, and I know it's late. Briefly, the testimony of the coroner. The prosecutor asked or posited that we had not shown to you, we had not proven to you, as if it's our job to prove to you, which it's not, how Jose Menendez obtained the shot through the thigh. And she then speculated that she thought that the shot to the thigh took place when, if I understand it, he was already sitting down and the leg was somehow up and moving. The coroner testified that all of the, first of all, Miss Bizanich's arithmetic is a little off here. She gives a little benefit of the doubt as to Mrs. Menendez and says, well, let's assume there were 7 wounds. And as to Mr. Menendez, let's assume there were 5 wounds. And there were 2 shots through the door. That makes 14. We know the guns hold 6. Therefore, there must have been 2 shots on the reload. The problem with that arithmetic is that the coroner testified that the number of wounds does not mean that that corresponds with the number of shots. And the reason for that is that he indicated that some of the shots could have been what he talked about as pass-through shots. That is, some of the shots, and some of them were distant shots, where some of the load from the pellets could have gone in Mr. Menendez, some could have gone in Mrs. Menendez. He also testified that it was possible that there were pass-through shots, that some shots passed from one person to the next. So the fact that there are 7 wounds does not mean that there were 7 shots. The fact that there were 5 wounds on Mr. Menendez does not mean there were 5 separate shots. So the arithmetic doesn't quite work. But aside from that, the theory of the prosecution, as I understand it, is that he is somehow sitting down when the leg wound, the thigh wound, is inflicted. I don't think that's the way it could have happened, because the coroner said, and she also indicated that the wounds to the back of Mr. Menendez must have been inflicted when he was already seated down. I think the coroner was pretty clear in testifying that the wounds to the back of the elbows of Mr. Menendez could not have been inflicted looking at the photograph in the way in which he was seated down, because the arms are covered by the couch. And the only way that could have happened is if you shot through the couch. I think if you asked to have that portion of the coroner's testimony reread, if there's any doubt about that, and that's generally what we do if there's some question about the evidence, that you'll see that the coroner was very clear that the wounds could not have been inflicted to the back of the arm when he was on the couch. And I think he was also clear that the leg wound could not have been inflicted when he was seated in the position that he's shown in the photographs, because the leg wound to the thigh was a shot that went from the inside of his thigh to the outside of his thigh. And he indicated that since there were no pellets found inside the wound, that the shots would have been blown out the outside of the leg, and there would have been some sort of particle of blood or pellet particle either on the couch or in the area immediately to the left, if he was seated in the position in which he is shown in the photographs when he received those injuries. And you'll see from the photographs, there is no particle or any sort of markings to the left of Jose Menendez's leg. So it could not be that he was seated. By the same token, the coroner also testified that the wound to the leg probably would have been incapacitating. So one possibility here is Jose Menendez, as you recall from Lyle Menendez's testimony and also Eric Menendez's testimony, was moving toward him at the point in time when the doors were burst open. And one possibility here is he has his arms up in some way, and he is shot in the back. And the coroner said the fact that he's shot in the back does not mean somebody's standing behind him, because if someone is moving their arms in some way, the shot could come into the back, and yet the shooter could be facing you. One possibility here is Lyle Menendez shooting from the door area into the back of the hands. Eric Menendez, meanwhile, according to his testimony, is moving from the doors around to the area in front of the TV, and according to his testimony, is just firing, randomly firing. There are shots into the French doors, two random shots that go through the French doors. There is exhibit number 17 are the pellets which were recovered by the coroner. And you recall the firearms examiner said that there were for buckshot, there were, according to his analysis of the evidence that was found both in the coroner's examination and evidence found at the crime scene, he indicated that there were 6 shots, at least 8 shots fired, 6 shots of buckshot and 2 shots of birdshot. And he said that the buckshot that was used contains 27 pellets per round. And he was asked if 6 loads of buckshot were fired with 27 pellets, would that mean 162 buckshot pellets and 6 rounds? He indicated that that would be the case. Only 56 of those pellets were recovered. And I believe it's exhibit 16 or 17, the actual pellets recovered by the coroner are in evidence. He indicated, I believe, that he did not recover all of the birdshot pellets. Some of those birdshot pellets were left in the bodies. But as to the buckshot, I believe he testified he recovered all the buckshot that he could. Maybe an error on that, but I think he said he recovered all the buckshot that he could from the bodies. And if you sat down and went through those envelopes, you would see that there are 56 pellets recovered, 56 individual buckshot slugs recovered. And if 6 shots were fired, that means 162 minus 56 did not hit the target. And we also know that there were 2 shots through the windows, which would indicate that there was some random shooting there by someone. And so one possible scenario here is Lyle Menendez shooting at a point in time when Jose Menendez is up and about, hits him in the back of the arms. At the same time, a shot coming in from the area of the TV from Eric Menendez through the left thigh, and the particle going out through the leg into the same area of the couch, which is covered by blood. And if you look at the portion of the couch where Jose Menendez was seated, you'll see blood in that area where he was seated. The shot blows out into the back of the couch. The shot to the leg incapacitates him. And at the same time, Lyle Menendez is coming forward. And the last shot in time would be the shot, which was the contact shot to the head, which he indicated took place very quickly after the first shot was fired. And the coroner also indicated that the sequence of these shots must have been very rapid. And he thought that the shots were very rapid because all of the wounds that he examined were anti-mortem wounds. And since some of the shots were fatal, the fact that there were no post-mortem wounds, meant to him that all of these shots must have been fired in very quick succession. That testimony is also consistent with the testimony of the neighbors who heard firecracker-type sounds, which were not interspersed by a great deal of space. So as to the defense not explaining exactly how this shot was inflicted to the leg, I think there is a reasonable interpretation of the evidence which would show how that shot was inflicted. And in any event, I don't think it's our burden to show how one shot or another was inflicted. The burden is on the prosecution. And then lastly, I wanted to talk briefly, because of the importance of the question, about the special circumstance allegation. And I hesitate to even talk about this because it's our very strong position in this case that, based on the evidence that you've heard and based on proof beyond a reasonable doubt, that by the end of your deliberations, you should be on this side, the left-hand side of this decision tree, not on the right over here. But because of the obvious consequences of a finding of special circumstances in this case, I want to talk just briefly about the two special circumstance allegations and also the charge of conspiracy. And I'll talk about the conspiracy charge first. And the reason I said earlier that the conspiracy charge and the murder charges require you to decide the same things is because of an instruction the court is going to give you about the conspiracy charge. And first, the court's going to tell you that a conspiracy is an agreement entered into between two or more persons with a specific intent to agree to commit the public offense of murder or manslaughter, and with a further specific intent to commit murder or manslaughter, followed by an overt act committed in the state by one or more of the parties for the purpose of accomplishing the object of the agreement. It's a very hard definition to follow. But you may ask yourself, well, if someone meets with someone else, and again, I challenge the prosecution to point to when the agreement was formed in this case. When was there a meeting of the minds between Lyle and Eric Menendez where they got together, and the court's going to say she doesn't have to approve an express agreement, but still an agreement must be proved to show that a conspiracy exists here. When did the conspiracy get formed? When did they come together, and what was the object of the conspiracy? And I challenge her to pinpoint for you what the charges are so that you can decide whether that charge is true or not. You may ask yourself, well, how can somebody come together and agree to kill somebody and not have that be a premeditated killing? Because if you agreed with somebody else in advance that the killing was going to be premeditated, that you were going to kill somebody, wouldn't that be murder in the first degree? And the court's going to give you an instruction about that, which says the fact that a killing was planned in advance, whether individually or in concert, does not prove that the planner acted with malice or with premeditation and deliberation. If, as a result of heat of passion, sudden quarrel, or an honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, a man kills without malice, he commits murder. It necessarily follows that if the same man, under those same circumstances, conspires to kill, he conspires to commit manslaughter. So you'll see under this instruction that this instruction requires you to go back to the evidence again and decide whether any agreement that did exist here, was that an agreement to kill which was formed as a result of heat of passion or the honest but unreasonable belief that someone was about to kill you. Because if two people think that they're about to be killed and they come together and say, you know, we're about to be killed, we got to do something about this, that may be a conspiracy. May not be, but it may be a conspiracy, but it's only a conspiracy to commit manslaughter, not a conspiracy to commit murder, because the agreement is formed upon the heat of passion or the unreasonable belief in the necessity to defend yourself. And then lastly, the special circumstances. As I indicate,
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
If and only if you decided the charges were murder and a charge was murder in the first degree, would you get to the decision of true or not true, the special circumstance. And the rules for special circumstances are exactly the same as for the charges. That is, they must be proved beyond a reasonable doubt and to a moral certainty. If they depend on circumstantial evidence, the same rule applies that if there are two reasonable interpretations, your duty is to adopt that interpretation which points toward innocence. And you'll see from the instructions that the exact same rules apply, obviously because of the consequences which follow a finding of true to the special circumstance allegation. Two special circumstance allegations that are charged in this case are multiple murder. And the court's going to tell you that to find the special circumstance referred to in these instructions as multiple murder convictions to be true, it must be proved that the defendant has, in this case, been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree. All right? Now, what that means is, suppose you looked at the evidence and you said, and I'm not suggesting you do this, I'm using this hypothetically because I want to illustrate the multiple murder special circumstance, but suppose you decided after viewing the evidence that Lyle Menendez was guilty of the manslaughter of Jose Menendez. And suppose, or he was guilty of second degree murder of Jose Menendez. As to that charge, you would stop because you would not have found it first degree murder. But suppose, just hypothetically, that you went back and you said, but I think as to Kitty Menendez that it's first degree murder. If you found that, and again, I am not in any way suggesting that that's a proper verdict, I think it's not. But if you were to find that, then the question would be, is the special circumstance of multiple murder true? If you had found that the charge as to Jose Menendez was manslaughter, then the multiple murder special circumstance would not be true, because in order for it to be true, the second murder would have to be murder, first of all, and it would have to be in the second degree. And you could switch it around. Suppose you found that as to Kitty Menendez, Lyle Menendez was only guilty of manslaughter. As to Jose Menendez, he was guilty of first degree murder. That would not, the multiple murder special circumstance would not apply there because you would need a second degree. It's only if you have a first degree and a second degree, or two first degrees, that you could find that the multiple murder special circumstance would be true. And I hope that that's clear. And that in turn goes back to the instructions that we've been talking about all afternoon. In order to find out whether it's first degree murder, you have to go through the analysis that I outlined in the charts. And it's only if you reach that point of finding one first degree and at least a second degree that you could find that the special circumstance would be true. And in that event, we'd have to have the second trial where you would decide the question of penalty. Suppose you found that the charge as to Kitty Menendez was manslaughter, the charge as to Jose Menendez was first degree murder. Of course, it was second degree murder and manslaughter. That would be the end of it. There would be no further determination of the special circumstance allegation because you'd have a second and a manslaughter. And under the chart, you'd end right here. It's only if you found, for instance, a manslaughter and a first, and in that situation, you'd say, well, the multiple murder special circumstance isn't true because we don't have a second. So you would find that to be not true, but your job wouldn't be over because the second charge has been made in this case, and that is the charge of lying in wait. And the special circumstance of lying in wait while lying in wait is a little bit more complicated than the multiple murder special circumstance. And I want to spend just a minute on it, and then I'm through. The instruction says to find that the special circumstance referred to in these instructions as murder while lying in wait is true. Each of the following facts must be proved. Number one, the defendant intentionally killed the victim. Number two, the murder was committed while the defendant was lying in wait. The term while lying in wait within the meaning of the law of special circumstance is defined as a waiting and watching for an opportune time to act, together with a concealment by ambush or by some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration is such as to show a state of mind equivalent to premeditation or deliberation. Then the instruction goes on to talk about what the term while, that part of the instruction tells you what lying in wait means. That is a waiting and watching together with a concealment by ambush. Now the instruction tells you what killing while lying in wait means. And it says, thus, for a killing to be perpetrated while lying in wait, both the concealment and watchful waiting, as well as the killing, must occur during the same time period or in an uninterrupted attack commencing no later than the moment concealment ends. If there is a clear interruption separating the period of lying in wait from the period during which the killing takes place, so that there is neither an immediate killing nor a continuous flow of the uninterrupted lethal events, the special circumstance is not proved. It's a little bit confusing, but what that means is there are two requirements here: concealment, lying in wait, and that the lying in wait occur while the and that the killing occur while the lying in wait take place. And the instruction then sums up what the elements are, and it says, a mere concealment of purpose is not sufficient to meet the requirement of concealment set forth in this special circumstance. However, when a defendant intentionally murders another person under circumstances which include, and now it sets forth the elements that you have to find. Number one, a concealment of purpose. Number two, a substantial period of watching and waiting for an opportune time to act. And number three, immediately thereafter, a surprise attack on an unsuspecting victim from a position of advantage. The special circumstance of murder while lying in wait has been established. If the murder is done suddenly, without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. So there are two things here. If someone is waiting and watching, and there's a time period between the waiting and the watching and the killing, then the special circumstance is not true, not because there wasn't waiting and watching, but because the killing was not while the person was lying in wait. It has to be both while lying in wait, and there has to be a substantial period of waiting and watching before the killings take place. That's an important distinction to remember in this case, if you ever got to that point, and God hopes that you don't, but if you ever got to that point, keep in mind that there are two requirements. It has to flow continuously from the period of waiting and watching into the killing. Otherwise, it's not while it's lying in wait. And if there's an interruption, then the special circumstance is not true. But more importantly, even to get that far of whether it's while lying in wait, you have to determine that there was a substantial period of waiting and watching for an opportune time to act. That's what a lying in wait means. And the ambush, when Ms. Bizanic says, well, as classic lying in wait is where I lie in ambush for you. I wait and watch for you, and when you come by, I kill you. That's classic lying in wait. And she said that she doesn't need classic lying in wait because the killer can come to you now. Well, that's not true. It still is required under this instruction that there be a substantial period of waiting and watching. Otherwise, a special circumstance is not true. And in this case, the prosecutor attempted to prove that charge by cross-examination of Lyle Menendez and by cross-examination of Eric Menendez. And they failed to prove it. And Lyle Menendez, on direct examination, was testifying about the moment in time when he was in the car and the guns were being reloaded prior to going into the house. And he said, I just grabbed a bunch of ammunitions out of the box and I was giving him Eric ammunition and we were just loading as fast as possible. Question, do you remember how many shells you loaded? I don't remember. I remember pulling out all kinds of shells and just loading my gun and having shells on me. Question, what did you do then? We went, my brother, I guess, had got outside through the study doors because he ran toward the study window door. And you had to kind of go over this. I think you had to, we went over the little concrete thing. It was over to the side of the door on the left. And we went through that door and we just went into the room hoping to get there when they were not expecting us. And on cross-examination, Ms. Pizanich asked Lyle Menendez in order to establish that there was a substantial period of watchful waiting. Question, now I take it before you and your brother burst in to kill your parents, you looked through these doors to see what they were doing. Answer, no, we weren't even sure that they were going to necessarily be in that room, but I was hoping. We just burst through the doors, and that's when I saw the shadows of people to the right, and I knew that they were in the room. Question, did you ever think to go into the kitchen and look through the door from the kitchen into that room? Answer, we didn't think we had time to be waiting and looking and stuff. I was just running as fast as I could, and so was my brother, and he got there first, and we just went right through the doors. And as soon as I saw something, I started firing. It was no time to just be watching and trying to see where they were exactly, and so on. And Eric Menendez was questioned along the same lines and gave the same answers. So there is a complete failure of proof in this case to show that there is a substantial period of watchful waiting. The prosecution may direct you to evidence of the statement that Lyle Menendez gave Detective Zoller on September 17th, where he said that my parents sometimes were in the habit of falling asleep. That evidence is contradicted by the maid that they didn't fall asleep in front of the TV. But in any event, that would go to the issue of whether they were taken by surprise. It would not explain the absence of proof on the period of watchful waiting. There is no evidence anywhere other than what I've just indicated to you, which shows that this was a crime, if it was a crime, where someone was watching and waiting for a substantial period of time in order to act. And so there is a complete lack of evidence as to the most serious allegation that was made in this case, which is a special circumstance allegation. I hope I haven't bored you to death with the law, because as I said at the beginning, the law in this case is the second most important thing that you as jurors have to work with in deciding whether the charges are true or not, whether they have been proven beyond a reasonable doubt. And I realize trying to teach you this at 3 o'clock in the afternoon is probably very difficult. You've been an incredibly patient group of people, and patient through all sorts of abusive ways that unfortunately take place when there are so many people involved. I, on behalf of Lyle Menendez, would like to thank you, because I'm not going to otherwise get a chance to talk to you again. And we appreciate your time and your attention. I sincerely believe that you will reach the correct verdicts in this case, and I have no doubt that you will conscientiously weigh and consider the charges and find, after consideration, that Lyle Menendez is not guilty of the charges that have been leveled against him by the prosecution. Thank you.
All right, thank you. And we'll resume tomorrow at 9 o'clock. Again, don't discuss the matter with anyone. Don't form any final opinions about it. Would it be easier for you to come in here at 9 o'clock or the courtroom next door? Does it matter to you? You want to be? All right, your first chance to make a decision here. Okay. All right. Okay. We got some people want to go over there. Okay, we'll see you tomorrow at 9 o'clock. All right.